Well, hey again, it's Rob Ryder, and it's Tuesday, November 29th, 2022. And today, original writ, JAG, and the UCMJ. This is where common law, executed by military due process, all comes together. All that's required is a couple of people to shake their heads the right direction, and all of what I'm going to show you could happen because it's all written in the law. However, right, it takes somebody on the other side of the counter to agree with us. If we can get that one person to, do the right thing to start the process, then the things I'm going to show you in this video could happen. So let's get into that a little bit. And I am Staff Sergeant Robert Allen Rutluski, U.S. Army veteran, also known as Rob Ryder, ROBBRYDER. My email address is courtofrecord@aol.com. And my YouTube channel is Rob Ryder with 3 B's, ROBBRYDER. And if you were to go to my site on YouTube, I'd ask that you did, especially if you're, anyway tied to the military, or as you'll see, I believe everybody's under the UCMJ, the Uniform Code of Military Justice, right? That at some point it would apply to everybody, but it would definitely apply now to, people that are veterans and so forth. At least that's what I'm trying to make happen, right? So if you're one of them and you've not watched my videos before, it's been a while, you should start here at Uncle Sam Ain't Released Me Yet and kind of watch all of these, all the way through here. Yeah, it's 8-9 hours of video, but it's the background for what I'm going to be talking about now, which is this. We'll get to it just in a second. Hang on. Yeah, so starting at Uncle Sam Ain't Released Me Yet, about that time, or maybe it's the next video in, I had done I was talking about this, right? That in the Uniform Code of Military Justice, under Article 139, right, you could have redress of injuries to property, right? Whenever a complaint is made to a commanding officer that willful damage has been done to the property of a person, that his property has been wrongfully taken by members of the armed forces, he may, under such regulations, the secretary concerned may prescribe, convene a board to investigate the complaint. And I had been saying for quite some time, right, that, the best I can tell, I've never been released from the military, nor has any other veteran, right? And so therefore, we're still in the military, and according to our enlistment agreement, speaking for the enlisted now, right, this is all legit stuff that they could keep you past your enlistment date. It's all written in the law, but at the same time, it's written in the law that if they do, they have to pay you, right? So where's my pay? And where's my ID card? Because I'm still in the military, and if you're in the military, under the rules of the Geneva Convention, you have to have an ID card, right? So, technically the United States is in violation of the Geneva Convention because I don't have an ID card. Of course, it's one thing for me to believe it, but, trying to get somebody else to agree with you is very, very difficult. But anyways, based on this then, I was working with Dana Reed Smith up in Kalkaska, Michigan, who's, had some really pressing issues we'd been working on before. And I said, and as it turns out, where Dana lives, in his township, it backs up to the back of Camp Grayling, which is in Grayling, Michigan, which is like the training grounds in Michigan, right, for the National Guard and so forth. And they have, people from all over the world come in to go train out in the northern woods. And so Dana said, well, I'll take it over to the commander, because as you saw in the UCMJ, it says, who do you have to give your complaint to? Right? Is made to any commanding officer. So let's go make it to a commanding officer. That was the idea. Well, as it turned out, that commanding officer, who happens to be Colonel Myers, was coming to his township for a township hall meeting because they're trying to buy some land from his township to expand the size of the Camp Grayling. And so instead of going to Camp Grayling and going through all that, Dana just waited until the day, which I think was October 5th, that they were going to have this hearing, and he went to the hearing. And he actually had things to say in the hearing, and then he caught up with Colonel Myers afterwards, and well, he gave him this complaint, right, which we'll go through in a second. But so the colonel took it, and he took it back with him, but he had to go to D.C. the next week. This was like on Wednesday, and he was getting ready to go to D.C. for a week, and Trump was coming to town, and there was all sorts of things happening, right, that were going on back at that time, getting ready for the election, all the other shit that they might be involved in. So he's really busy. But he said he'd give it to the JAG officer for the Michigan. Yeah, I can't want to say VA, but no, Michigan National Guard to look at. Wait, not hearing anything, and finally we do, and then Dana gets to have a conversation with this JAG officer, and then was able, actually he got a call the day before, missed the call, called me, said, hey, I got to call this JAG officer in the morning, would you be available for a phone call? I said, sure, put all this into it, let's see if we can get an answer from, if you're going to be talking to a JAG officer, let's see if we can get JAG to agree with us. And, well, JAG didn't really want to agree at the beginning, right? The typical. So, for instance, he was saying, well, the colonel really can't do anything. It's not in his. You're not in his jurisdiction, right? That Dana would have to go to the Navy because he was in it's a Navy issue, and but it looks like we were trying to have our records, fixed, which, and then they have this process for doing that. And while we do want to get the records fixed, we want to have the injustice corrected and then get the records fixed, right? Because the injustice is that if we're still in the military, we should have been getting paid, then where's our pay? Where's the ID card? Where are these things? Because you never released us from the military. So now this phone call that we had with the JAG guy was a couple weeks ago, and it was just before the big snowstorm, right? So, having this phone call, and all of a sudden the snowstorm comes, then the next week is Thanksgiving, and, kind of here we are now. We haven't really talked to him again since, but where he was very, what would you say? I won't say defensive, that isn't the proper word, but, hard to convince about anything at the beginning. We could talk for like 40 minutes, Dana said. And so Dana's mainly, listen, I'm just, ratchet jawing, just, telling the guy every fact I can think of, So that by the end of the conversation, the guy, he's starting to agree with us, right? That we may have crossed the bridge, right? Gave him enough evidence that we have some idea what we're talking about. But what we needed to hear, and I don't know that we did, although it was really close, is that veterans are still subject to the UCMJ, right? Because if we're subject to the UCMJ, which is military justice, then first of all, you cannot be tried by a civilian court. Then, if the civilian court wants to try you, they have to go to the military to get you released. And specifically, if they want to try you by an indictment of a grand jury, they can't do it, right? It's violation of the Fifth Amendment to try somebody in the military by the indictment of a grand jury. And in the UCMJ, it says, to try somebody of a crime, which is what an indictment would be for, is a crime, right? In the military, your accuser has to, basically get somebody who's subject to the UCMJ to file charges and specifications against you, right? And that's a particular thing, right? An indictment's one thing, and charges and specifications is another. It's a particular process to, charge for a crime. Well, this is the way you have to do it in the military, and that doesn't happen. And so we have, many, many veterans and actually people that are in the military now that are sitting in jail based on the indictment for something that happened on January 6th, 2021. It's one of, the other great injustices in the world. So none of these people should be there, because at least the ones that are subject to the UCMJ, because they're tried by a separate justice system, and this has all been agreed to by the Supreme Court, right? And I showed that. So that's what I'm saying. If you watch the videos where I said to start from and go forward, I've talked about all these things, showed where it came from. All this shit's happening, right? So, and the other thing that it sounded like he said is that yes, we could take our complaint up the chain of command. Because one of the questions I asked him is, well, who's the general court-martial convening authority? And he said, I think it's General, Paul Rogers, Paul R. Rogers, maybe something like that. And he's the adjutant general for the Michigan National Guard. And, and so in this conversation we had, he was coming to agree to a lot of things, but the one thing I know he didn't want to agree to, in fact, it's the only thing I can remember where he said, well, that's just crazy talk, is the fact that on the DD4 form, for any enlisted person who enlisted, right, when you enlist, you're enlisted into the Armed Forces of the United States. But when they discharge you, they give you a discharge, right, certificate from the Armed Forces of the United States of America. Which would mean, well, then I wasn't discharged from the Armed Forces of the United States, which is the place I went into, and this is where it comes in. Well, then I'm still in the military. Just go ahead and pay me. You decided to keep me. I mean, that was all part of the agreement. I have an agreement with the United States, right? Because that's what we're talking about here. That says if you keep me, you're going to pay me. And I want my ID card because if I'm in the military, and I want my Geneva Convention ID card. All these things. So that's what this complaint was about. This is because of this, because this is the agreement you went in on, and it was never canceled because this is the discharge certificate that you get, then obviously, like in my case, some of the Army is withholding my pay because I'm still, I still got a contract. Or in Dana's case, it's the Navy, right? Or same for the Marines. Air Force have their own. Space Force got their own now, whatever it is. It's just, well, if you enlist, this is the document you enlist on, no matter who you are, and it says Armed Forces of the United States. Well, he did not want to admit that Armed Forces of the United States and Armed Forces of the United States of America are not the same thing. He said, that's just crazy talk. The first time he said that to me, I said, oh, and then we moved on to conversation. I had to ponder that for a second until we got to it again. And he says, well, they're the same thing. One's just a trade name for the other. And that's where I said, sir, that's a lie. And then I followed up by saying, well, sir, I know that you're a professional liar. I mean, it's part of your job. I'm just telling you, that's a lie. They are not the same. They will never be the same. You cannot make me agree that Armed Forces of the United States is the same as Armed Forces of the United States of America. So I'm not taking your answer for this shit anyways, but I'm just letting you know I don't agree. We need to bump this thing up the chain of command. And that's, so later in the conversation, he did say we could bump up the chain of command. I know, I tell you, it's a long story, all these little pieces, but, this is what happened. Well, from that then, having done some more research, since because of the snowstorm and the prolonged week of Thanksgiving and so forth, I had, some extra time to look at some things, and we'll get into those in just a little bit. But what it is that in the UCMJ, there are actually two courts, right, other than the court-martial, which is done by a general, but there's actually, two courts in the UCMJ. And both of those courts have this jurisdiction called All Writs Act jurisdiction, which means they can issue any writs they need to, do whatever they're supposed to do. Well, there's lots of different kinds of writs, right? One of them is called an original writ, which is the one we'll be speaking of mainly, but, but this is where it started with. So anyways, on this unsworn statement then that we filed, or that Dana took over to the commander, that because he did that, allowed all these other things to happen. That's what the whole story was about. Because Dana got off his ass, went down to someplace and handed it to the guy and, didn't take it back, although he didn't ask him to take it back. But, if you're going to go to all this trouble of taking something to someplace, leave it there. right? Even if they say I don't want it, so now you've been served, leave it, and walk away, right? But that isn't the way the commander did it. The commander took it and he allowed Dana to talk about it. And what did the commander do? He went back and gave it to JAG and said, here, you deal with this. All right, because this is what it said. Sir, it's with great displeasure I must inform you that my property is being wrongfully taken by the Armed Forces of the United States. I declare that there are intentional errors and omissions in the U.S. Navy, Department of Defense, and other federal government official records that adversely affect status, privileges, pay, and identification I am entitled to as a member of the Armed Forces of the United States. And I ask you to convene a UCMJ Article 139 Board of Inquiry to investigate, right? It came right out of the UCMJ. We should be able to do this, sir. Right? Let's all salute the flag and say that that's what it said. We could bring it to you. So we did. Okay, so as an example, according to my enlistment agreement, right, his DD-214, he enlisted in the U.S. Naval Reserves of the Armed Forces of the United States. But the discharge or certificate of discharge for him, right, this is Navy now, says he was discharged from the Armed Forces of the United States of America, and it's United States Navy. Neither of which have anything to do with the enlistment agreement with the Armed Forces of the United States. Right? They're just a completely separate issue. It has nothing to do with your original agreement. Signed agreement. Signed by you and signed by the representative of the United States, right? It's a binding contractual agreement. In fact, had I been discharged in the U.S. Naval Reserves, I would have been awarded the U.S. Navy Honorable Discharge lapel pin and my DD-214 list and listed as an award. It's all true. No such indication in my DD-214. Sir, as my discharge certificate contains false statements and the U.S. Navy Honorable Discharge lapel pin is not listed on my DD-214, there appears to be no evidence I have been discharged from the Armed Forces of the United States, U.S. Naval Reserve. My DD-214 evidence is I was transferred to the Naval Reserve, and it makes no mention of my discharge from military service. Right? It's my belief that I'm still under contract with the Armed Forces of the United States, and our agreement states that while under contract, I'm entitled to pay allowances and other benefits. That's in Section 9 of the title of the Form 4, right? The DD Form 4 says this is you're entitled to pay allowances and other benefits, all of which are now wrongfully taken from me. I did not serve United States Navy of the Armed Forces of the United States of America described on the certificate of discharge, and this document's creation is proof of a scheme by someone in the armed forces to wrongfully take my property and disenfranchise me of entitlements contractually owed me by the Armed Forces of the United States, or just from the United States, period. To make matters worse, our United States is now in violation of international law of war for the failure of the Armed Forces of the United States to provide me a Geneva Convention identification card required by Department of Defense Law War Manual and international law service members are to possess. It's all a matter of a fucking, international agreement called a treaty. Please be advised that according to Section 4012, certificates of service, right? Pay attention to this. We'll come to this again, right? To get that. Under Section 4012, certificates of service, persons reported missing of the Service Members Civil Relief Act. So technically, it's just called 4 U.S.C. subsection 4012, right? That a certificate of service under the signature of the Secretary of the Navy is prima facie evidence of my individual service facts it contains. Right? So the person that can clear up all this shit with just one document is, his case is the Secretary of the Navy. He can issue a certificate of service under his signature that will stand as prima facie evidence of Dana Reed Smith's current past service. Right? Only the certificate can prove my service. And I asked the commander to convene the UCMJ Article 139 board investigation to investigate my complaint and procure this certificate to determine all facts concerning service for the investigation. I have so no, whatever we included. So basically, right, we wanted him to go to the convene a board, have the board because it can gather evidence and so forth, to request this certificate from the Service Members Relief Act, which is 50 USC 4012, which says this, it gives all these parameters to be on that certificate, all pertaining to the service member. And it's not the same one as what they get if you were to go to court today, where they're going to act like they're going to go get the certificate they're supposed to do. It's not under the signature of the Secretary of the Navy or the Air Force, Army, whoever it is, so it's not the same certificate. Okay, so that's what we gave them. That's what they looked at. That's when they said, well, it looks like you're trying to get your records fixed. No, sir. The records will be fixed. What we're saying is we want our pay, right? We have a contract. The contract's been isn't being followed by the United States. Now, I'm not blaming the United States yet. I'm saying somebody in the military is keeping me from my pay, and that allows me to have this on Article 139 hearing, and they can gather all the information and figure it out. Okay, so, well, the JAG officer, ended up saying, well, the commander up at Camp Grantley, he isn't going to do anything with this. Right, so, okay, you can say what you want. I mean, he needs to tell us, sir, but that's fine, But, but we can take it up the chain of command. So that's where it was all sitting. And then I found the stuff we're going to talk about now that goes along with all this. That's further into the UCMJ, and that it may be a much better way for anybody who needs to get some kind of extraordinary relief if you can prove that you're subject to the UCMJ. Right? That we have our own doorway to get extraordinary relief. And so what it is that right here, subchapter 12, United States Court of Appeals for the Armed Forces. Right, there is a court of record known as the United States Court of Appeals for the Armed Forces. This court is established under Article 1 of the Constitution. This court is located for administrative purposes only in the Department of Defense. Right, so it's not in the Department of Justice, or it's not a judicial court, right? It's a legislative court created by the legislature. It's not an executive branch. It's not a judicial branch. So for me, I said, well, that's a big deal, because that would mean that these particular judges do not need to take the oath to satisfy the 6th article of the Constitution that an Article 3 court is supposed to have. Like the court that we believe we go to when we go to like the United States District Court for the Western District of Michigan. They want you to believe that's an Article 3 court. But if that was an Article 3 court, then the judges and the magistrates would have had to have executed the oath that's in Statutes at Large, Statute 1 Stat 23, right? First statute, 1 Stat 23, 1 STAT 23. First law of the United States after ratification of the Constitution. It says right in it that, this is the oath that satisfies the 6th article of the Constitution of the United States, right? In the following form, to wit, I state your name, do solemnly swear to support the Constitution of the United States. Period. Well, nobody's taken that oath. And so if they didn't take that oath just the way it says to do, just like the law said to do it, then they didn't take the oath and they don't have any authority, because they have to have a certificate or a record, possession of, to prove that they took the oath before they can exercise any powers of their office. So nobody in Congress has done this. They're all supposed to. Same with your state legislatures. They're supposed to have done it. All judicial and executive officers of the United States and of the several states are supposed to have done it. But not military officers and not legislative officers. Right? It said judicial and executive. So the reason for that, that's a big deal, is because if you're going, for some reason, you get pulled into a federal court, especially by an indictment, well, that court is not an Article 3 court. It's just pretending to be one. Right? So they're going to try you by an indictment. And the United States of America is going to be the plaintiff. But the United States of America is a dominion of King George III and his successors. It's a crown possession that has, by the Treaty of Peace 1783 or Treaty of Paris 1783, whatever the proper name is, right? Has international agreement to be here. It's like a private society in the United States, but it's not the United States. It's a private society that has, basically hijacked us or shanghaied us and put us in their jurisdiction. It's, said that we volunteered to it and they want to keep us there. Where the jurisdiction we need to get out of it is actually through this court here called the United States Court of Appeals for the Armed Forces. I'm going to show you why in just a second. Okay, so here's the rules of practice and procedure for United States Court of Appeals for the Armed Forces. If we go down here to jurisdiction, we will see that it has a jurisdiction to do extraordinary writs. The court may, in its discretion, entertain original petitions for extraordinary relief, including, but not limited to, including, but not limited to, writs of mandamus, writs of prohibition, writs of habeas corpus, writs of error cor nobis, see 28 U.S.C. 1651, which is basically the All Writs Act. And these other rules here, absent a good cause, no such petition shall be filed unless relief has first been sought in the appropriate court of criminal appeals. Original writs are rarely guaranteed, right? Original writs are rarely granted. Well, it comes to find out there actually is a writ called original writ. Just like there's a writ of habeas corpus and a writ of prohibition and a writ of error cor nobis, right? Those are all kinds of writs. And there's no one called an original writ. And so even though this is appeals court, it didn't say that it had to be for an appeals reason. It can do it for original petition. Not, because you're appealing anything. It's just original. You're asking to have extraordinary relief. And so it's going to be good to know, well, what are these writs? And, we're going to go look at a little Blackstone here to see what that is all about. All right, commentaries and laws of England. Because, because it's a writ, it's common law. And by common law, I mean the laws of England, right? That's the only common law I care about. What did Blackstone say? Because this is the book that the founding fathers used as their basis for setting up the country's law system based on the laws of England. They were talking about, Blackstone. Somebody told me before that their kin came across in a wagon train, and everybody had two books. They had the Bible and had Blackstone's commentaries. Right? These are people going in, wagons across the frickin' United States. They carried the Bible and they carried their Blackstone. Well, in Blackstones, so this is easy enough to find online. This particular one is no longer online, but just Google commentaries, the laws of England, and then specifically you want to find chapter or book 3, which is on private wrongs. 18, right? Pursuit of remedies by action, and first of the original writ. So I'm just going to, speed read a few of these things. We'll get to the meat here in a second. But basically, right, I proceed under the title of injuries cognizable by the courts of common law to define and explain the specific remedies by action provided for every possible degree of wrong or injury, as well as such remedies as are dormant and out of use as those that are in everyday practice. Right, by action in the courts of common law, and then by proceedings in the court of equity. Right, so you can have an action in a court of law, for a court of common law, and you can also have a proceeding in a court of equity, either of which can get the the proceeding in the court of equity will be to get the original writ to take to the court of common law to have it heard. Right? Because you get the writ from the Court of Chancery, which is a court of equity. It'll all be explained here in just a second. I'm just showing this is, right out of common law. That's what Blackstone said. So we're bringing the common law now because these military courts have jurisdiction in the All Writs Act. And writs are English common law. And let's see what it tells us we can do. All right. In order method wherein proceedings themselves follow each other rather than to distract, I subdivide into and subdivide it by any more logical analysis. The general, therefore, and ordinary parts of a suit are the original writ, process, pleadings, issued demurrer, trial, judgment, da da da. What was the first thing? It was the original writ, right? And so we got to do number one first. We don't need to worry about anything else till we get number one done. So first, then, the original or original writ, which is the beginning or foundation of a suit, right? I mean, that's a mouthful. It's the beginning or foundation of a suit. You got to have an original writ. When a person has received an injury and thinks it worth his while to demand satisfaction for it, he is to consider with himself or to take advice, right, counsel, what redress the law has given for the injury, and thereupon is to make application or suit to the crown, the fountain of all justice, for that particular specific remedy which he's determined or advised to pursue. As for money due on account, action of debt, for goods detained without force, action of detention trover, if taken with force, action of trespass, I believe that's under arms, or to try title, lands, writ of entry, action of trespass and ejectment, all these things, right? So to this end, he is to sue out or purchase by paying stated fees an original or original writ from the Court of Chancery, which is the office of justice, basically. The shop or men of justice, wherein all the king's writs are framed. It is mandatory letter from the king in parchment, sealed with a great seal, and directed to the sheriff of the county wherein the injury is committed, or supposed to be, requiring him, the sheriff, to command the wrongdoer or party accused either to do justice to the complainant, you, or else appear in court and answer the accusation against him. Right? So if you get this writ, which is an original writ that can be issued under the All Writs Act by the court, legislative court, to to be directed to the sheriff of the county wherever the thing is you're complaining about. So, now what is it you're complaining about? Well, in my case, I'm going to complain that that the Army is withholding my pay. Same with Dana. So now I need a writ. That's my problem. All right. Well, that's what they're supposed to. They're supposed to write the writ. I just need to know what the problem is, and then they write the writ. But it's that writ that they write that goes to the sheriff. It says, "Sheriff, go talk to these people here and tell them they got 10 days to either make right for this dude or come into the court, right? This federal court here, this armed forces court, and answer the charge." Right? And so they give them like 10 days or whatever it is, right? So this is like order to show cause, a true common law order to show cause. So whatever the sheriff does in pursuance to this writ, he must return or certify to the Court of Common Pleas together with the writ itself, which is the foundation of the jurisdiction of the court, being the king's warrant for the judges to proceed to determine the cause. For it's a maxim introduced by the Normans that there should be no proceeding in the common pleas before a king's justices without his original writ, because they held it unfit that those justices, being only the substitutes of the crown, should take cognizance of anything but what was thus expressly referred to their judgment. In other words, they work for the king, so you bring the king's writ, we'll hear it. You don't bring the king's writ, we're not going to hear it. However, in small actions below the value of 40 shillings, which are brought in the court baron or county court, hey, that's kind of what we end up going to now, no royal writ was necessary. But the foundation of such suits continues to be, as it was in the time of the Saxons, not by original writ, but by plaint. Right? A plaintiff. So if there's a plaintiff involved, it's technically, by common law, a small action with a value of less than 40 shillings. Right? So you think about in the Constitution where it says, the common law right to a jury is preserved for controversies more than $21. Right? I'm just saying, well, that must be a 40 shillings. It's about 21 bucks. If it's more than that, you get, your right to a jury is preserved. If it's less than that, you don't necessarily get a jury. Right? Because they created these courts to do, to have this lower jurisdiction. So it could be the same guy hearing the case. It's just, is he hearing it for the county and the county court, or is he hearing it for the king and the king's court? It depends on what was brought to him. Did he get an original writ under the Great Seal, or did he get a plaintiff? Right now we keep going as plaintiff instead of getting the original writ. So now, indeed, even the royal writs are held to be demanded out with of common right on paying the usual fees. So I could say also, now there are other federal courts that claim to have all writ jurisdiction also, right? The ability to issue writs. So, but when you go to these places and it says United States District Court, let's say the United States District Court for the Western District of Michigan, when they reply, it'll say U.S. District Court, Western District of Michigan. Right? They changed the name of the court. So, but continuing on, now this is where you get to the, what is this original writ type stuff? So, original writs are either optional or preemptory, or in the language of our law, they are either a praecipe or a CT something or other, which is I give you security. The praecipe is in the alternative, commanding that the defendant do the thing required or show reason wherefore he has not done it. The use of this writ is where something certain is demanded by the plaintiff. I want my pay. Right? I want our agreement. I want our agreement complied with, which is in the power of the defendant himself to perform. Well, that would be the Secretary of the Army. He could do it. As to restore the possession of land, to pay certain liquidated debt. Yeah, how about that? Right? If they owe me, it's a debt. To perform a specific covenant, right? Like, comply with our agreement. To render an account, right? How much you're holding back, so forth. All those things, those types of things, right, can be done by a praecipe. In all which cases, the writ is drawn up in the form of a praecipe or command to do thus or show cause to the contrary, giving the defendant his choice to redress the injury or stay in the suit. Right? So we don't even need to have a court case if we can get this done ahead of time. That's why it's called a praecipe, and it's a preemptory. We don't have to have a court case. We don't have to have a trial. You could just fix it right off the beginning. But the other one then, the other species of original writs is I'm not very good with Latin. We'll just leave that there. From the words of the writ, which directs the sheriff to cause the defendant to appear in court without any option given him, provided the plaintiff gives the sheriff security effectually to prosecute his claim. So what that could be now is if you have, like me, I have general liability insurance on my name, Robert Allen Maluski, right? So I can give the sheriff a certificate of insurance, because one of the things that's covered by general liability insurance is a malicious prosecution. Right? This writ is in use where nothing is specifically demanded, but only a satisfaction in general to obtain which administer complete redress, the intervention of some judicature is necessary. Such are writ of trespass, or in the case wherein no debt of a specific thing is sued for uncertain, but only damages to be assessed by a jury. Or you've been damaged, your property's been damaged. That's what this is, property damage. For this end, the defendant is immediately called upon to appear in court, provide the plaintiff give good security for prosecuting his claim. Both species of writs are tested and witnessed in the king's own name. Right? The security here spoken of to be given by the plaintiff for prosecuting his claim is common to both writs, though it gives denominational into them later. The whole of which is at present becomes a mere matter of form, and John Doe and Richard Roe are always returned as standing pledges for the purpose. So it's a formality now. The point is, where do you get the writ? Right? You don't just go to the window of the court case and you say, I want to file this court case. You have to start with this thing called an original writ. There's all sorts of people trying to go start court cases, but they don't have an original writ. Right? And so if you don't have an original writ, it's really for a case that has a value less than 40 shillings. So that's what's going on, right? Well, I have something that's worth much more than 40 shillings, right? It's, whatever is mine, so I want it all. Right? I'll decide what I want to do with it, but I, want to get it out of their hands. And so this is something that can be done by the Armed Forces Court. So hang on just a second. All right, so the United States Court of Appeals for the Armed Forces, right? The United States Court of Appeals for the Armed Forces is an Article I court that exercises worldwide appellate jurisdiction over members of the armed forces of the United States Armed Forces on active duty and other persons subject to the Uniform Code of Military Justice. Well, this is the point. If you can get them convinced, the frickin' JAG, that veterans are, under the UCMJ, then, it applies to us. Right? The court is comprised of 5 civilian judges appointed 15-year terms, reviews decisions from the Army Corps of Criminal Appeals, the Navy, Marine Corps Court of Criminal Appeals, the Coast Guard Court of Criminal Appeals, the Air Force Court of Criminal Appeals. Look at all them different courts. I don't have time to go do it right now, but if you were to go to this court here, this Navy, Marine Corps Court of Appeals, the actual court site, you would see that they handle claims under admiralty law. And all people, a lot of people keep talking about everything is under admiralty law, admiralty law, admiralty law. Well, you know what? They have a court. It's called the Navy and Marine Corps of Criminal Appeals, which handles admiralty cases. But, hey, that isn't this court. This one is above those courts, right? So these are courts that are actually in active duty, in active duty positions. Where this other court here is a civilian court, right? So it's not an active duty position, but it's not a civilian court. It's a military court with civilian judges. And I kind of like their seal, because we got rid of the drunk woman with the blindfold on, right, with the freaking uneven scales, and replaced it with a double-edged sword, which can cut both ways, and even scales. That's beautiful. And which I also liked was this, right? This is the building that it's in. Right? What's it say at the top? United States Courthouse. And there's only one court mentioned. What court is that? Let's see. All right, United States Court of Appeals for the Armed Forces, right? That's the only court in the United States Courthouse. Now, this is on, like, Judiciary Square or something like that in D.C., and it hasn't always been this court, but it is now, and it says United States Courthouse, with courthouse being one word. And, you go look around and find another courthouse that says United States Courthouse on it, without anything added. Because you may find, like, United States Courthouse and Post Office and da-da-da-da, or, the name, somebody's name United States Courthouse and Post Office, or U.S. Courthouse, or Federal Courthouse, but not United States Courthouse. In fact, I wanted to show this other one. Right, this one says United States Courthouse. Now look at this one here in this one down in Tampa, Florida. It says United States of America. Right, doesn't even say nothing about United States on it. Right, but here it says United States. Right, it's not on the building. United States Court, space House. Right, in the United States of America. It's not the same jurisdiction. And so, since this court has an appeals court below it, this is like the second appeals, right? This is actually the United States Supreme Court, which isn't necessarily the same thing as the Supreme Court of the United States. SCOTUS, that's another place. But this is the United States Supreme Court. It's the only building that says United States on it, and this is the highest court in the military structure before it has to go to SCOTUS. So in the United States, which is under martial law, has been since 1863, everybody that has a gold fringe flag is, in the jurisdiction of the martial law government, and they're actually all, contractors who were contracted to do some function that started to act like the government instead, and we've been bamboozled by these fuckers our whole lives. But right, it's the United States of America. It's a foreign jurisdiction to the United States. Right? And so if you're under the Uniform Code of Military Justice, then you're in here. Now, who else is it besides people in the military? Well, people in the Red Cross are supposed to be in here also. And I did videos on this a long time ago, right? That, like, you could go to the Red Cross website and you could give them $10. Become a volunteer for $10. Use your credit card, pay it. Now you're a voluntary member of the Red Cross. I say that at a time of war, like we're in now, that puts you under military protection. Right? So now you're under the UCMJ. You have the right to trial by court martial and all the other stuff that goes with it. But once you get into this jurisdiction, right, it doesn't just have to be against you. It's like, well, we should be able to use it for ourselves. And that's what this original writ stuff is all about. That's what we use to get some kind of relief. Right? Here's another proof. Here's an indictment of a grand jury, right? And who's the plaintiff? Or, it doesn't say plaintiff, but in the plaintiff position, United States of America. Against Jeremy Brown, where this man's name is Jeremy Michael Brown. And Jeremy Michael Brown is a master sergeant, United States Army retired, and he's definitely under the UCMJ because all retired members are still in the UCMJ. That's pretty much common knowledge. Right? Yeah, he was tried by a grand jury, which is unconstitutional. And they're proceeding in the court case. In this United States District Court, Middle District of Florida, right? Which, these buildings, as we saw in one case, it says United States of America on the top. It doesn't say United States. So that's out of, what we would call a district court, federal district court. Now, where was something I had here for, here it was. Right, this is an ongoing case in the United States Court of Appeals for the Armed Forces. Right, now it's the United States. Right, not the United States of America. Now, they do have this guy's name with a D, but you know what? As it turns out, when you did your paperwork as a enlisted person, there's one line you sign on there where you certify your name with a middle initial. And then there's a whole thing in the Title 10 about if you serve under a fictitious name that you can, go back and have your records changed into your proper name if you want to. So you could serve in the military under a fictitious name. So that doesn't, to me, so this is still correct. It's just these people are serving under a fictitious name. But the United States is the United States. It didn't say, the United States of America. And another important thing here is in Rule 33, this is, the Armed Forces Appeals Court, right, the one that says United States Courthouse, it says for good cause shown, the court may suspend any of these rules in a particular case on application of a party or on its own motion and may order proceedings in accordance with its directions. So this court can do whatever it needs to do to give somebody relief. They don't have to say you didn't follow our procedure, which is normally what they tell you, right? You didn't file the fucking procedure, so we're not going to allow you to have any relief. It doesn't matter if you're correct about what you're saying. You didn't follow the court's procedure. That's a biggie. And then just real quick, one last thing here. We'll just look at what it takes to do this, right? Because this is where was it? Right here. Extraordinary relief, right? Petition for extraordinary relief. Didn't say petition for a writ, right? You're going to petition for extraordinary relief, and they're going to decide what writ it takes to fix it. A petition for extraordinary relief shall be filed within the time prescribed by Rule 19D, shall conform in some length to 24, in accordance with 39, be accompanied with proof of service on all respondents. The petitioner shall also provide a copy of the petition to any trial or appellate military judge whose decision, judgment, or order is the subject of the petition. Okay, right? So it doesn't have to have any of these, or all of these, can have some of these. Right? Provide a copy of petition of any trial or, okay, well, I don't know if there is one, so it doesn't matter. If there isn't, there isn't. It's an original petition. The petition for extraordinary relief shall be captioned in RE, right? And then name the petitioner. Well, that would be us in the RE, Robert Allen Rutluski. The petition shall contain a history of the case. I'm enlisted. Never discharged. I think I got money coming to me. I want my pay and I want my freaking ID card. Right? And so, the things you want, the issues presented, a few things, and that's all it takes. And then if they would just agree with it, then the judge can issue an original writ to the sheriff of the county, which in this case would be the District of Columbia, to the Secretary of the Army, say, hey, you got 10 days to make right with the claimant, or you're going to have to come into court and stand for trial. I'm sure that'll get something to happen. Okay, so again, this is no answer to anything. This is just I'm presenting something brand new that I, should have known from having already read these things, but now I do know because I've looked at them and I can fit it together. To me, it's pretty cut and dried. This can all be done, but it would be done by JAG. Or it isn't that it couldn't be done by a lawyer outside because we're trying to get an original writ petition, but it's the court that you give it to, right? This is like venue shopping, right? That you would want them to send it to this venue here, not to the District Court of Michigan, Western Michigan. No, I want mine to go to the United States Court of Appeals for the Armed Forces, right? For an original writ, asking the Secretary of the Army to, give an accounting on my account and pay me whatever I'm owed. Because I've never been discharged, and here's my, like myself, I have the agreement. We'll worry about fixing the records later. Right now, let's get the relief, and then they can, fix the records to match the relief. Okay, very good. I'm going to leave it there, and we'll see how this goes, right? So that's the idea for Dana and I, is to now go back to the JAG officer and tell him what it is we want him to do. Because at the time we had this conversation, we weren't really quite sure what we wanted to do. We knew what was wrong, but we may not have known the proper relief to ask for. So now that we do, we can point at it and say, well, this right here, I want to have this original writ from this court for this reason. And because I'm subject to the UCMJ, right? I get to go to this court. That's the whole thing. This court you only get to go to if you're subject to the UCMJ. Excuse me. And one last thing before we go. Well, look at that real quick. Who is it exactly? Right? In the Uniform Code of Military Justice. We're all listed in 2. Persons subject to this chapter. Right? Regular components, volunteers from time to time, cadets, while on inactive duty training, members of reserve component. Right? So I believe I'm in the little R reserve component. I'm in the organized militia as a reserve component of the Army on some kind of inactive service status. Or I went into the hospital, right, to get my evaluation for being discharged, and I never came out. And now I'm on disability retirement, living somewhere in the hospital. Right? I never left the hospital. And I can say that because on my, there's 2 things. You got to have a medical exam, you got to have a dental exam, which is part of it's a hospital exam, I think they call it. Anyways, dental is part of medical, and they're not separated in the military, right? So you have to have these things before you can be discharged. And on my DD-214, it clearly says I never did, and I never signed it. So it's like, well, where did I go? I never even finished out processing. So all this stuff is hidden in the paperwork someplace, and, I'm saying here's a way that we can try to get to it. So there's something here about subject to any treaty, agreement in the United States, party may be accept the rule of international law. Well, that would be member of the Red Cross. Anyways, all these people here are subject to the UCMJ. And this is, for every enlisted man, the voluntary enlistment of any person who has the capacity to understand the significance of enlisting in the armed forces shall be valid for the purpose of jurisdiction under subsection A, and a change of status of civilian to member of the armed forces shall be effective upon taking an oath of enlistment. And once that's done, you're in, you're not coming out. So we should have access to this court. All right, the United States Court of Appeals for the Armed Forces. That's what we're going to find out next. I'll let you know how it goes. Okay, y'all have a great day. God bless.